Before we can undertake any business, Jules, how you doing? Good to see you. Yeah, Roger's usually here. Well, we've now got a quorum. Nobody's left the room. Well, welcome everyone to the committee's meeting for Thursday. I want to also recognize I know a couple of members of our Judiciary here, two former presidents, I believe, of the Judicial Council, Judge David Emerson and Judge Gosselin. I think you're here for your bill this afternoon, are you not? I wonder if it's good. Well, happy to have you. That's right, Douglas County. We've got three bills. I know Senator Stone, you're number one on my list, so if you want to come up, and we'll let you tell us about Senate Bill 95.
Thank you, Mr. Chairman. Senate Bill 95 improves the statewide master jury list. This is brought to us by the Clerk's Council. We have Mr. Mike Holloman here from the council to answer any difficult questions. But what it does, it addresses a problem with the current method of forming the statewide jury pool that leads to excessive duplication in names. This provides a way to have a secure, unique identifier for every person that goes on the statewide jury list. And the bill is divided up. By the way, that statewide, that secure, unique identifier is based upon the last four digits of a Social Security number run through an algorithm behind the firewalls of each agency from which potential names are submitted. The agencies will generate these secure, unique identifiers. Starting with the Department of Driver Services, dealt with in lines 27 through 41. This will be done in consultation with DDS and the Clerk's Council. We move down to the Secretary of State's office. Also will provide information. It will retain under current law identification as to race. Ethnicity will no longer be something required for the statewide jury list. The other agencies that are providing names include the Department of Public Health, which actually would be shrinking the list because of the death certificates that they generate. The Department of Corrections is the next agency, same process with them. And then also the State Board of Pardons and Paroles, which would add to the list where individuals have their civil rights restored. The Georgia Supreme Court will retain the authority to establish rules and reasonable standards for preparation of the jury list. With that, I'll be happy to try to answer questions or defer to Mr. Holloman.
Are there any questions, members of the committee? Let me ask one thing. You mentioned about the Department of Health removing them. Are they going to have the information as to this assigned number, or how will they know on a death certificate what?
I would assume they do,
Smith,
but for probably a better answer, I would defer to Mr. Holloman, whether or not on a death certificate you'd have that. I don't know if the Social Security number is on a death certificate or if they have.
Don't think generally. Is it on there?
To my knowledge, it is, yes.
So your Social Security number is on your death
It would be the
certificate?
same process as for all of the other agencies.
Okay, interesting. All right. Any further questions? If there are none, we appreciate it, Senator. We'll see if there's anyone else who wishes to address the committee on Senate Bill 95. If there are none, we'll close off further public comment. The bill is now in the breast of the committee. We're dealing with Senate Bill 95, which is LC 297424S.
Second.
We've got a motion due pass, which has been seconded. Any discussion on the motion? No discussion on the motion or any amendments? There are no amendments. The chair will call the main question, which is due pass Senate Bill 95. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Thank you, Senator.
Thank you, Mr. Chairman.
I'll see you later this afternoon.
We'll look forward to it.
Next, we have Senator Kennedy on SB 126.
Good afternoon, Mr. Chairman and
Good
members of the
afternoon,
committee.
sir. Good afternoon.
Thank
And
you
this
for
is
allowing me
on-
to appear. Sir?
This is LC 2974443S,
Yes, sir.
Senate Bill 126, a venue bill. Yes, sir. Tell us about your bill.
Mr. Chairman, this bill, as I think everyone on the committee knows as an attorney, that with regard to suing the state has sovereign immunity, and along with that, excuse me, certain limitations when it comes to venue and other items that fall under that umbrella. For a long time, it was assumed, based on the reading and interpretation of 5021-28, that the proper venue for an action against the state was, in essence, where the loss occurred, which was believed to have been in your typical road wreck case where the car accident occurred. However, there was a decision from the Court of Appeals rendered last February of 2016. That's the Board of Trustees versus Jordan, in which the court defined loss much more broadly than it had previously been defined, and loss in that instance was included things such as pain and suffering, such as where medical attention was received, and a whole host of other things that fell under the definition of loss for purposes of this statute, which effectively meant or means that venue against the state in an action under this code section really can be in any of our 159 counties. So that puts us in the odd posture of someone suing the state having much more broad selection for venue than would a traditional civil litigant of a plaintiff suing a defendant. So the language is being proposed to correct that, to bring that back into line with where we believe it should be and where it really has traditionally understood to have been, begins on line 11, so that it provides that the Superior Court of the county wherein an added tort giving rise to the loss occurred, and it is believed that will then further define it so that venue will be sort of, in my example of the road wreck, where the car accident occurred. Lines 12 and 13 address the fact that a wrongful death action is a separate cause of action, one separate from personal injury, and provides that that cause of action is recognized to be in the county where that may have occurred or would occur if, in fact, it's separate from where the original tort giving rise to the loss occurred. So you could have an example of my road wreck case where if the road wreck happens in one county A and the death occurs in county A, then venue would only be in county A. But if you have the road wreck in one county and a subsequent later death somewhere else, you would have potentially two venue site locations. So that, Mr. Chairman, is the what's offered by this bill, and believe that should bring things back into check with regard to the limitations, appropriate limitations for venue selection when someone sues the state.
Thank you. We have questions. Mr. Fleming.
Thank you, Mr. Chairman. Senator, thank you for your explanation. You did a real good explanation, subcommittee, and I even understood it.
Thank you, sir.
A little bit, I think. But I was taking notes, so I could explain this later on if necessary. You said you had the case. Was that the case? Did you
yes, sir.
name that or not?
The case the case that I referenced is the
This is the one that overturned the
yeah,
original had
yes,
the bill.
yes, yeah. That's
Oh, there it is.
Board of Regents versus Jordan. That, Mr. Chairman, is 335 Georgia App 703.
Board of Regents versus.
Jordan, Jordan.
Okay, yeah, the chairman handed it to me right here.
Okay.
And also the chairman and I discussed an amendment to provide for applicability going forward. In other words, all actions occurring on or after July the 1st, 2017, when it would become law. Do you have a problem with that? Make it prospective rather than looking backwards.
I don't think I do conceptually. If you don't mind, I'd like to ask my departmental representative. I'm carrying this bill for the. May she come forward?
Rebecca Sullivan,
Yes,
Mr.
sir.
Chairman.
Ms. Rebecca Sullivan, yes,
Mhm.
sir. Being St. Patrick's Day almost.
Thank you, Mr. Chairman. I think that I think that if that's the will of the committee, that would be fine.
I think what we're looking at is not wanting to upset something that may be already pending. Again,
Right.
we like to try to avoid being brought in the middle with legislation of something maybe an ongoing case. Not that we're aware of any, just to say that if there is one out there, it's recognized we're not trying to change the law in the middle of a case.
So would the amendment that you've proposed apply to any action that is filed
If the
after
incident
July 1?
occurs, incidents occurring after a certain date.
Would there be a problem with changing that to any action that is filed after July 1, as opposed to any of the underlying tort occurring?
I'm trying to think if that's generally done that way. I don't know that we usually talk about, because usually what you base your venue on is the incident itself when it occurs, as opposed to timeliness of when an action may be filed or not. We'll talk about it when we get to the point on that, but your preference would be to an action as opposed to the incident itself.
Yes, sir, but I certainly
Conduct
trust your
giving rise
judgment
to
here.
the cause of action. Okay,
Thank you.
thank you. That's just one of the things we're gonna bring up as a part of this
Okay.
review of the statute. Now, you actually have case law that deals with this question about where a venue rests with a death case. That's an old case you got. When I say an old case,
That's the
not
1998
real old,
Evans case?
1998.
Yes, sir, 1998 Evans
That's
case.
the Georgia DOT versus Evans case.
Yes, sir.
And that holding was recognizing you could have venue either where the incident occurred or where death occurred.
That's
So
right.
death
yes.
is the ultimate injury, you might say, that caused, although it's secondary to the first underlying tortious act that may have brought about ultimate death. Okay.
Yes, sir.
Could I ask one follow-up question about that? And I know you said this once before, and once again, I'm trying to recall everything we talked about yesterday. The reason we're codifying that in the statute is why? I know it's case law, and we've been doing it for 20 years, but we're codifying it right here now. Was there something about that, the more recent case that affected that?
Well, the February 2016 case, yes, it changed the interpretation of and definition of loss, so that it has resulted in this really universal venue anywhere in the state. And to my understanding, that was the first case that did such. And so without this codification, that precedent would control and would dictate that would be venue unless otherwise changed by statute, which is what's being proposed.
So the 16 case upended the 98 case that said you can file wrongful death action, no? I
No,
misunderstood you, I'm sorry.
Yeah, the 16 case changed how the definition of loss was interpreted.
Okay.
And that's what expanded it and blew it so far. It is the 1998 Evans case that first recognized, and I believe is still good law, that for the wrongful death action, that can be in a separate venue.
Two places.
Yes, sir.
Where it happened or where you pass.
Yes.
Okay, and so something about the 16 case causes us now to have to codify the 98 matter, though, right?
No, it was just a matter of compromise, really.
It's it's desired by the Georgia trial lawyers.
It was the trial lawyers in working with
Yeah.
Ms. Sullivan and their interest, and they came to the compromise position of including the language and basically recognizing the principles
Gotcha.
in Evans
Okay.
Put by
in that
statute.
portion.
Yeah.
Yes, sir.
All right, so we're just putting in the statute what's been in law for 20 years almost.
Yes,
Gotcha.
sir.
Okay.
Mhm.
Thank you.
Further questions of the presenter? Excuse me. If there are none, we appreciate your comments, Senator Kennedy. Let me see if there's anyone else in the audience who wishes to address the committee on Senate Bill 95. Yes, sir, Mr. Clark. You'd like to come forward, and we'll give you if you want to sit over here or there, either one.
I'll be very brief, Mr. Chairman. On behalf of Senate Bill 126, we've agreed to this compromise, but to further answer Representative
I
Fleming's
said one.
question,
I'm sorry. Yeah. My mistake.
the reason I think that we need to now codify the DOT versus Evans case is because it turned on the same definition that the Jordan case turned on, namely the word loss. And so we're going to codify now, not that loss where loss occurred is the focal point of venue, it's where the tort occurred. And so a court after this day, after it passes, could say, well, does that call into question the wrongful death case because the tort may have happened in this county, but the death happened over here. So the legislature, one could argue, is overturning DOT versus Evans. Not the intent of anybody that I'm aware of, and certainly not Senator Kennedy's or DOAS's or GTLA. So we just sort of, let's not buy further litigation over a question that you can answer definitively by codifying the pre-existing case. At the same time, you codify the change from loss to where the tort occurred.
Yes, sir, go ahead.
So one fix could have two effects rather than one effect, and we're gonna make sure one fix has one effect.
It's a 2-for-1 day here at the Capitol.
Gotcha.
Mr. Chairman.
Okay,
Yes, sir.
thank you, thank you.
Let me ask, as far as law beyond the claims against the state, in this case, we're looking at action where there'd be one against the state of Georgia for a wrongful death. If you just, any other type of wrongful death, do you have the same applicable provision where you can have it occur either in the county where the incident occurred as well as in the county where the death occurred?
You're talking about outside of the Tort
Yes, sir.
Claims Act?
Yes, sir. Do I know?
I honestly don't know off the top of my head where venue lies for non-government actor tortfeasors and where a wrongful death
Because
case happens.
that particular
just don't
case
know.
applied only to the situation interpreting this act.
That's right, and there may even be some language where it refers to where the state alone is the defendant,
Yeah.
this venue provision applying. But to be most candid with you, I don't know the answer to your question about
Curious.
non-government cases.
Thank you. Any other questions by members of the committee of Mr. Clark?
Thank you, Mr. Chairman, members of
Thank
the
you.
committee.
Do we have anyone else in the audience who wishes to address the committee on Senate Bill 126? If not, we'll close off further public comment. The bill is now in the breast of the committee. We have a motion do pass. Thank you. Been seconded. Do we have any discussion on the motion? There being none, do we have any amendments? We have an amendment, Mr. Fleming.
Mr. Chairman, this is what we discussed just a minute ago about the applicability of Senate Bill 126 and whether or not it would be prospective only. And we were having the discussion at that time whether or not we would make it apply to prospectively to when causes of action arising after July the 1st, 2017, or causes of action filed, or rather causes filed afterwards. And I guess that would be the appropriate time now for you to give that some
If you would
thought.
like to, yes, you want to present your motion?
Well, I'm kind of asking you which one you'd like for me to present.
Well, my preface is I think the need is to really recognize when the incident occurs as the appropriate place where now the measurement of time is not always, I don't think always a valid way of trying to say where you may have a right to bring an action, but certainly.
So causes of action arising on or
Cause
after
of
July
action,
1st,
right.
2017. That'll be my amendment then,
Yes,
Mr.
sir.
Chairman, that we would add on line 3, and let me hand that to Mr. Jordan because I know.
We have AM in your folder, AM 410269.
Which would provide on line 3 in the caption changing to provide for applicability, and then of course the actual change would be adding between lines 19 and 20. This act shall apply only to the causes of action arising on or after July 1st, 2017.
We have a proposed amendment. Do we have a second on the amendment? It's been seconded. Do we have discussion on the proposed amendment? We'll have a vote on the Fleming amendment. All in favor signify by saying aye. Opposed, like sign. Motion carries. As to the amendment, we're back to the main question. Are there any further amendments? There are none. The main question is a do pass to Senate Bill 126, which is LC 297. I'm good for that. LC 2974443S as a committee substitute as amended. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries.
Is it 0-1?
Yeah. Thank you.
Thank you,
Senator.
Mr. Chairman,
See
and
you at
thank you
4
to the
o'clock.
committee members. Yes, sir. See you then.
We next have Senate Bill 132. Senate Bill 130, there you are, Senator. Oh, you're not in the audience? I think it's your first time before our committee.
I thought they'd all
Senator
want to stay
Tiller.
and see my dramatic and brilliant performance, Mr. Chairman, but I,
We do. We're all waiting for it. Glad to have you with us.
Thank you,
Senator.
Mr. Chairman. Thank you for allowing me to be here.
Yeah.
Members of the committee, the members of the subcommittee perfected this bill. I appreciate their help too.
We're on LC, just about announce that we're on LC 41-1169 ERS.
Yes, sir. This is Senate Bill 132. It really does three simple things. One, as many of you know, when we file cases now, you have a civil case filing initiation form. You also have disposition forms at the end. Those are currently in code. This takes that out of code, allows the Judicial Council to write that. They have to then be approved by the Supreme Court. It takes those out of code so they can be dealt with more easily. Right now, they're a little bit cumbersome. A lot of us probably delegate that task to our paralegals because they don't go to the merits of the claim. This tries to make it a little bit more effective for what it's actually meant to do, which is to help with case counts. The second thing that this bill does is it changes a transmission requirement. Right now, the paper form and the data are required to be transmitted by the clerks. We don't need the paper form anymore in the 21st century. All we really need is the data. And that data is now, right now, it's transmitted to the AOC through the AOC portal, the Administrative Office of the Courts. And the paper forms go to the GCAC, the Georgia Commission for the Automation of the Courts. Just don't need that paper transmission any longer. Thought about doing away with GCAC completely and eliminating a commission, but the reason that this bill does not go that far is because the state has some preferential contracts with the GCAC, and we're afraid if we eliminated that it would also cause us some issues on those preferential rates currently. The third thing this bill requires is that the data be returned to the standing committees of Judiciary in the House and the Senate of the General Assembly every year, just so we can analyze how our changes are affecting policy. And I appreciate Chairman Fleming with his help on the wording of that. And that's really, I hope that's it in the summary. If David Emerson from the Judicial Council is here to speak if he needs to, but I think.
Judge, you want to speak on the bill? Would love to have your thoughts about it. Come on up and take a mic.
Thank you. I serve as the chairman of the Workload Assessment Committee, and that's the committee that counts the cases and makes the recommendations to the Judicial Council for the judgeships. And what I'm trying to do here is just simplify these forms and take out a lot of stuff that we're just not able to gather and that we've never been able to collect. And we're also overhauling the way we count cases as far as we currently, if you look at it on the domestic filing sheet, you have 6 categories of domestic contempt. We just don't need that kind of refinement. You have 6 categories of tort. I've agreed to leave in a general category for tort and one for medical malpractice because I think that's of interest to the General Assembly. But as I say, we're trying to simplify the case count system and simplify the work of everyone involved in gathering this information, and also eliminate language in the statute that's been superseded by actual real world, the way we transmit information now. That's all it is.
Okay. Thank you, Judge. Do we have any questions of members of the committee of either Judge Emerson or the good senator? Apparently do not have any. Do we have anyone else who would like to address the committee on Senate Bill, lost the number, 132? There are none, then we'll close off further public comment, and the bill is now in the breast of the committee. Do we have a motion? Motion is due pass. In your file, I see a sheet 81, AM 41, 0268. And these are proposed amendments. Tell me, Jordan, the background on this.
This is the change. After reviewing the language provided in subcommittee, looking at it in context, it was thought that we could tweak the language and make it better with the following amendment.
Have you seen the amendment?
Yes, sir,
Okay.
Mr. Chairman, and I'm okay with them. In fact, I appreciate the House committee for perfecting the Senate bill.
Always. What we do best. Often. Yes, sir. Mr. Fleming.
It just wants Ms. Holloman, you seen the amendment too? Everybody's good? Okay, great,
All right.
great.
Do we have a proposed motion as to the amendments?
I'll move on them, Mr. Chairman.
All
wanna do
right.
them all at once,
I think we can do them all at once.
or
We'll do,
three of the ones
yes,
on
sir.
41, 268?
Everyone has a copy of this in your file. Thank you. Any discussion as to the proposed amendments? If there are none, the chair will call the question on the Fleming amendment. All in favor signify by saying aye. Aye. Opposed, like sign. That motion carries. We're back to the main question if there are no other amendments. Main question is a due pass of Senate Bill 132, which is LC 411169 ERS, as a committee substitute and as amended. All in favor signify by saying aye. Aye. Opposed, like sign. That motion also carries.
Thank
We
you.
appreciate your efforts on this good bill, and we'll see you later.
Yes, sir.
Thank you. There being no further business to come before the committee, we will stand adjourned.